arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games, and I'm not going to accept the disrespect. Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Well, you are.
And it looks like we are going in 21-36426 and 22-39.
That exchange right there, quietly huge. The prosecution had just suggested the defendant fled to Houston and had to walk it back after mixing up cases. Now, does that automatically help the defense? Not necessarily. But moments like this can impact how the judge weighs credibility and reliability during the hearing. Courtrooms move fast, and when facts start blurring together, defense attorneys absolutely notice. This is the kind of subtle courtroom tension casual viewers miss, but legal watchers catch instantly.
050, correct?
There's also a dismissal in between 05.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Okay.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't.
So after all that, the judge lands in the middle. Not the defense's requested $50,000, but not the original $1.5 million either. That tells you the court saw some room for adjustment, but still considers this an extremely serious risk case. And don't miss the conditions: GPS monitoring, house arrest, strict supervision. Translation: even if bond is posted, freedom would come with a digital leash. Now here's the big question for you. Do you think the judge struck the right balance here? Was this bond still far too high or too low?
Didn't do it.
I thought that's what the plea was.
There's a plea agreement, means in my court, you either enter a plea of guilty or not guilty.
Guilty. Okay.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no contest because he never even went over the indictment with me.
I find that hard to believe. So here's the thing.
Actually, be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture bond here.
Yeah.
So the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from...
And just like that, the temperature in the courtroom jumps about 100 degrees. A probation revocation is already serious. But once a murder indictment enters the chat, everything changes. The judge now has to balance two competing questions. Is this defendant a danger to the community? And will he come back to court? That's why bond hearings in murder cases become less about convenience and more about risk assessment. And trust me, the number attached to that bond is about to become a major battleground.
2018, you had 5 years or 4 years to indict me to actually send that indictment.
Sir, the allegation. I'm not going to allow it. Here's the thing. I don't have to accept any plea agreement. Okay? So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games, and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement, and you can go on, do your time to be done with it, then we can get that done. But you're not going to show disrespect.
Whoa, from $1.5 million down to $50,000? It's not a small adjustment. That's a legal Hail Mary. The defense is basically arguing he's not a flight risk. He's not dangerous if monitored. And the current bond is excessive. But here's the catch. In murder cases, judges rarely slash bonds dramatically unless there's a compelling reason. So now the courtroom is listening for one thing. Does Mr. McRae sound stable, credible, and rooted enough in the community to justify the kind of reduction?
That's what we're doing to me. Do you understand? So if you want to go forward, we'll go forward. If not, we'll set a trial. Mr. Smith will get ready very quickly, and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
If you go to trial, listen to me. If you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty. That's your choices. So let's go.
This moment may sound awkward, but legally it matters a lot more than people realize. The court wants specifics, addresses, family support, living arrangements, because vague answers can hurt credibility. The judge hearing, "I'll probably stay with somebody somewhere," is very different from hearing, "I'll stay at this exact address under this exact supervision." Bond hearings are often won or lost in these tiny details. And let me ask you this. If you were the judge, would these answers make you feel confident enough to release someone facing a murder charge?
Go back in and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th, 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's not assaulting me. Evading arrest is guilty.
It's evading arrest or detention with the use. I'm looking at your indictment.
You're saying you got indicted for
I got that.
for evading. In 2014, you were.
Hold on. This,
Okay.
you've probably already tried. Let me take care of it this way. Place that in front of your client, please. Now, that is cause number 21-36.